Are you prepared to navigate the legal complexities and financial intricacies of being an executor? Do you know what your responsibilities are as an executor? If you've been asked by a parent, spouse, or friend to be the executor of their will, you have to understand that it's an extremely important responsibility, and there are nuances that you should be aware of. So welcome back to this free series on probate, executorship, and some of the common questions and issues that you might face on this topic. My name is Steve Parr, and I'm an estates and business lawyer from Vancouver, Canada, and I'm here to cover everything that you need to know about being an executor of somebody's will. So first, it's going to be your responsibility to manage the deceased person's estate, which will include distributing the assets, paying debts and taxes, and handling all legal matters. This will be a complex and time-consuming process. Second, as an executor, you need to be organized, detail-oriented, and able to work well under pressure. You may have pressure from the beneficiaries of the estate, and it will help you to have a good understanding of financial and legal matters, or at least feel comfortable communicating with lawyers and accountants, and otherwise seek professional advice as required. Third, being an executor can take several months to a few years, so it's important that you be available during that time after the deceased person's death. Fourth, being an executor can be emotionally challenging, especially if you were close to the person who passed. You may need to handle difficult conversations and conflict amongst family members. Fifth, if you are a beneficiary of the will, this could in turn create a conflict of interest that might make it difficult for you to carry out your duties as an executor impartially. Now, if you do take on the role of being an executor, this can be a meaningful way to honor the trust and confidence that the deceased person had in you. However, you should never feel pressured into taking on such a significant responsibility if you don't feel like you are up for it. If you are named as an executor in a will, you are not obligated to accept the responsibility. However, if you take any actions as executor of the will, changing your mind and giving up the responsibility is much more complicated. So don't get started unless you intend to see it all the way through. So be sure that you want to take it on. But let's say that you do accept the role as an executor. What is next? This can be a confusing and stressful process, so I'm going to share with you a list of responsibilities and deep dive into some of the more complex topics. First, here's a list of some of the simple, self-explanatory tasks that you need to prepare for. First, arranging the funeral and what happens to the body, locating the will, reviewing the will, and gathering relevant information to be able to apply for probate. Once the court has issued a grant of probate, this essentially gives you the legal authority to now manage the estate, which is where it gets more complex. First thing you'll want to do is notify the beneficiaries and creditors. This should include the date of the grant and the information on how to contact you. For creditors, this may include credit card companies, banks, or other creditors who the deceased person had any loans with. Before distributing any assets, you have to pay any outstanding debts and taxes owed by the estate. This includes filing the terminal tax return or the final tax return for the deceased person. Once all debts and taxes have been paid, you can distribute the remaining assets to the beneficiaries as per the instructions in the will. Note that you must wait 210 days after the receipt of the grant of probate to begin distributing the assets, unless you get properly executed consents for early distribution from all of the beneficiaries. Failing to abide by this important rule can result in personal liability to you as an executor. You should also obtain a clearance certificate from the CRA before starting the distribution process to certify that there are no outstanding taxes. Once this has been completed, you must prepare a final accounting of the estate. This details all the assets, debts, expenses, and distribution. Once this has been approved by the beneficiaries or by the court, you can apply for discharge of your duties as the executor. Now, if in accordance with the will, you need to liquidate any assets, the process will include several steps. First, you'll need to have your grant of probate before you can start liquidating assets. Next, create an inventory of all the assets and debts of the estate. This should include real estate, personal property, bank accounts, investments, and any outstanding debts and liabilities. Then you will determine the value of the assets, which may include professional appraisal or valuation for certain items. The next step is to pay off any debts and taxes, and then you can start to sell the assets. You do have the option of hiring a professional estate liquidator to assist you with this process, or you can do it all yourself. Once the assets have been sold, you can distribute the money to the beneficiaries in accordance with the will, provided that you've already obtained the clearance certificate from the CRA. So that was an overview of some of the steps of executorship and some of the considerations. In the next video, I'll be discussing some of the answers and solutions to some of the common questions and problems that you might face as an executor. So if you want to watch that and any more free content on estate planning and business law, subscribe to the channel. Thanks for watching.